Hello, everyone. Welcome to our Week 6 lecture on international human rights law. Um, this is our lecture or our last lecture before the mid-semester break. So well done on getting halfway through the course. I hope it has been enjoyable, interesting, maybe a bit exciting, or if none of those things, not too taxing to get through. And our latter half of the course will be delving more into the specialized areas of international law. So is lots to look forward to. And I hope that you are looking forward to a week break and it's not too taken up by assignment work. Now, this week, like I mentioned, we're looking at international human rights law. Um, and as always, my approach here is to substantiate a little bit further some of the points made in your textbook. And so I'm hoping to kind of speak alongside your text on this issue. However, the structure of this lecture is a little bit different to your textbook. So I'm going to start by going through the so-called like substantive content of international human rights law. And then I'm going to turn towards a discussion on more of the historical development of even the idea of human rights and human rights law internationally, as well as their critique. Your text starts with a brief note on the history, goes into the substantive content, and then ends with a relatively brief note on human rights law. However, I feel the approach I'm going to take in the lecture melds a little bit better the critique and the history, because I think you really can't separate the critique of human rights law from the history, because that critique has certainly changed over time with the development of international human rights law. So this is why the lecture is structured this way, which is a little bit different from your textbook. But hopefully you're still able to engage with this lecture alongside the textbook itself. Now, here are the learning objectives for today. As you can see, we're addressing more centrally some of the key international human rights frameworks, as well as some of the ideas around human rights more broadly as well. And like I mentioned, we will end with a critique of human rights too. And I'll touch, the what I do with or what I hope to do anyway with the looking at the history and the critique is certainly the part perhaps that is more broader than your textbook. So I really want to give you a good feel of the history and the broader critiques there, because I think this part of the textbook is very, very brief. And I feel that's something that I can add to your learning in this area. So, I mean, the best place to start in terms of the substantive discussions around international human rights law is looking at the Universal Declaration of Human Rights. And this idea, this inherent idea of human dignity, which is at the center of a lot of human rights discourse, was formally adopted by the Universal Declaration of 1948. And importantly, in 1975, the Helsinki Accords affirmed that all of our human rights and freedoms derive from the inherent dignity of the human person. So that idea of human dignity is really, really crucial to human rights law in terms of our international law. And the substantive human rights that we now see has evolved from the practice of states and international organizations, the jurisprudence of national and international tribunals, and also broader like moral and ethical standards. And these have been articulated, these human rights have been articulated in numerous declarations and multilateral and regional treaties dealing with political and civil rights and economic, social, and cultural rights. Hello. Sorry, my cat Layla is is being a very keen observer this afternoon. The and I mean going back to this idea of human rights. I'm sure my cat is much more interested in cat rights, but that's probably another topic for another day. the UN General Assembly's Universal Declaration of Human Rights that we're talking about here of 1948 provided kind of the common standard for human rights upon which formal treaty commitments have subsequently been founded. So when we're talking about treaties and other conventions dealing with human rights, it's good to think about this kind of originating with the Universal Declaration. And this declaration, although it wasn't meant to be and not intended to be legally binding, rather not blinding, sorry, legally binding, the declaration set the human rights goals for the 20th century. And it includes a comprehensive list of civil, political, economic, social, and cultural rights. And really, still, it provides the inspirational, leadership for human rights initiatives within the UN, for new constitutions, and even for decisions of national and international tribunals. So, in a sense, even though it wasn't intending to be binding, it's come to represent something of customary law. And the 30 articles of the Declaration, which you can see the children having a look at in the picture, include the rights to life, liberty, and security, equality before the law, equal protection under the law without discrimination, a fair trial, to be presumed innocent, freedom of movement, to seek asylum, to have a nationality, to marry, have a family, to freedom of thought, conscience, sorry, and religion, freedom of expression, as well as peaceful freedom to have peaceful assembly. So really broad areas, and we do actually kind of come back to a lot of these points in later topics, especially under looking at asylum seekers, for example, and other points dealt with in the Declaration. It also includes social and economic rights as well, such as the rights to social security, work, and rest, to take part in the government, to an adequate standard of living, to education, and to also participate in the cultural life of the community. This declaration also importantly prohibits slavery and torture, arbitrary arrest, detention or exile, arbitrary interference with privacy, family, and reputation, and the arbitrary deprivation of property. And these rights and freedoms, though, are not absolute. They're usually subject to defined limitations and may not be exercised contrary to the purposes and principles of the UN as well. And any state-imposed restrictions on the recognised rights and freedoms must be for the purpose of ensuring the recognition of the rights and freedoms of others and to meet the just requirements of morality, public order, and general welfare in a democratic society. And this is spelt out in Article 29. So it does set, it does, I guess, provide some measures for restricting of these potential rights, if it's for a broader goal to meet, just requirements of a moral, public welfare and public order in a democratic society. So now let's move on to some of our core international human rights treaties, which, like I mentioned, have kind of been birthed from the ideas around human dignity and human rights, which are encompassed in the Universal Declaration. And the leading human rights treaties, which we really have to mention first, which have attracted ratifications by the overwhelming majority of states, are the International Covenant on Civil and Political Rights, or the ICCPR, the International Covenant on Economic, Social and Cultural Rights, or the ICESCR, as well as the four Geneva Red Cross Conventions of 1949. I don't really spend too much time on the Geneva Conventions at this stage. I think it is something we come back to a little bit later, and I don't think your text goes into it too much detail at the moment. But that is something we will return to later on in the semester. But there's also really influential treaties as well at different levels, rather than just the ICCPR and ICESCR. For instance, the European Convention on Human Rights, the American Convention on Human Rights, the African Charter on human and people's rights, and the Arab Charter on human rights as well have all been, like I said, quite influential in not only ensuring international human rights are implemented, but also building relative norms for international human rights as well. Now, while these various instruments vary in reflecting their particular regional or political concerns, they almost always include core provisions that are common to all such agreements, which provides evidence on the customary law status of these fundamental rights. Um, and just like I mentioned before, and the kind of the main treaty which informs all others, the Universal Declaration of Human Rights has been recognized officially, or as officially as it can be, I guess, as customary law by the International Court of Justice. So this has really demonstrated that these regional agreements, these other human rights treaties, as well as the Universal Declaration, have all been really vital in creating international human rights as customary law. Now, we will talk a little bit about enforcement of human rights soon. And as we will discuss, states have often not met their reporting requirements under the various human rights treaties that are there. And as states only quite infrequently bring complaints against other states, the enforcement of human rights depends more or less on procedural mechanisms, which we'll talk about in more detail. And for a lot of the international human rights mechanisms, there's what's called a locus standi, which basically means that individuals as well as non-governmental organizations have the right or capacity to bring an action or appear in a court to complain about um, uh, uh, the failure of implementing human rights, and they complain to treaty-based committees. And this has had quite a transformative effect on the evolution of jurisprudence in the international human rights law area as well. And it's been through the work of treaty bodies charged with monitoring implementation, who we'll mention soon, and of international, regional, and domestic tribunals that human rights have been given some kind of legal effect. Um, and a lack of progress in the implementation of human rights is most evident where these kind of procedural capacities do not exist, even though substantive rights may have been adopted within a state itself. If these kind of procedural capacities to allow people and organizations, for example, to lodge complaints, then often these human rights aren't implemented, they aren't upheld. Now, I think, do I go to my next slide here for yes, the ICCPR. So we're going to now focus on the ICCPR and the ICESCR. Like I mentioned, they're really the two of the very fundamental instruments that we have for international human rights law. And they also differ a little bit from the Universal Declaration as well. So, I mean, one of the main ways that the ICCPR, for example, which we'll talk about first, differs from the Universal Declaration is that the civil and political rights of individuals and minorities were given really detailed legal content in the ICCPR in 1966. In 1966. And these were present in the Universal Declaration, but they were really fleshed out in the ICCPR. And these rights as well of individuals and minorities, the civil and political rights especially, have been adopted with other important variations in different regional treaties that we've briefly mentioned before, like the European Convention, the African Charter, and the American Convention on Human Rights. And also by various other treaties with respect to specific kind of rights, which we'll also bring up later in the course, like the Convention on Torture, the Convention on the Elimination of Discrimination Against Women, the Convention on the Rights of the Child, and the Convention on Migrant Workers as well. Now, for the ICESCR, this is also extremely important instrument, and there were some economic, social, and cultural rights included with these civil and political rights within the UN Charter. Their differing characteristics of economic, social, and cultural rights were thought to require treatment in a separate covenant. And so this is why we have the International Covenant on Economic, Social, and Cultural Rights, because it provides us, in contrast to just to civil and political rights, with a progressive implementation and also a differential implementation in light of the relative economic resources of each state. And you can see that the language of the ICESCR, Article 2, demonstrates quite a relatively weak nature of the obligations which are accepted by states. Compared with those under the ICCPR, which called for an immediate implementation. So just to read to you, Article 2 of the ICESCR, it says each state party to the present covenant undertakes to take steps individually and through international assistance and cooperation, especially economic and technical, to the maximum of its available resources with a view to achieving progressively the full realization of the rights recognized in the present covenant by all appropriate means, including particularly the adoption of legislative measures. And also Article 3 is important to this too, where it says developing countries with due regard to human rights and the national economy may determine to what extent they would guarantee the economic rights recognized in the present covenant to non-nationals. So this primary responsibility for the implementation of the ICESCR lies with the UN Economic and Social Council, and specifically the Committee on Economic, Social and Cultural Rights, or the CESCR, which comprises 18 independent experts. And this was established in 1987 to review and comment upon state reports as they sought to achieve the kind of goals enunciated by the ICESCR. And unlike the Human Rights Committee, which we'll mention later, which has kind of a broader overview, and kind of consistent with kind of consistency in that idea with the progressive achievement of economic, social, and cultural rights. The Committee on the Economic, Social, and Cultural Rights, or the CESCR, doesn't have power to receive state or individual communications, and it's not as direct often with its critique as like the Human Rights Committee might be. But the UN specialized agencies, as well as non-government organizations with consultative status with the UN, do have a right to submit written statements to this committee, the Committee of Economic, Social and Cultural Rights. And it has been through primarily its general comments and concluding obligations in response to reports that the CESCR, this committee, has interpreted and applied the rights recognized by the ICESCR, like the equal right of women and men to the enjoyment of their rights set out in the covenant, which is especially focused on like the right to work, the right to enjoy just and favorable conditions of work, inclusive of remuneration and safe and healthy working conditions, equal opportunities for promotions, opportunities for rest, leisure, reasonable working hours, and paid holidays, the right to form and join trade unions, the right to strike, and the right to social security. And in certain general comments that the committee has made in the past, when it's considered the nature of the obligations imposed by the covenant under that, progressive realization of many of these rights, it has observed that states are bound to guarantee that all these rights, even as they're kind of progressively achieved, are exercised without discrimination. So they can't be achieved for one particular group over another, for example, internal to each state. States are bound to take steps that are deliberate, concrete and targeted as clearly as possible to meet their obligations under the covenant and to use all appropriate means, as the committee's comments had said previously, to do so. And this might include legislative, administrative, financial, educational, and social measures alongside judicial remedies. And the committee also affirmed, and this was kind of a bit more relevant, in the early years of the committee's founding, it affirmed that the rights set out in the ICE-SCR can be realised in a wide variety of economic and political systems, and this was very specifically speaking towards the, I guess, like plurality of political economies we saw, especially with the Cold War, which is not so much the case now, where most countries do have what may be classified as a neoliberal capitalist system. But at this time, the committee said, countries of different political economies have to still try to meet these rights set out in the covenant. And even if they don't quite get there, they have to ensure that they kind of progress towards it in a democratic sense, and also respect all human rights. And it also further kind of said as well in an important comment, this was in the late 80s, I believe, that these rights can be achieved progressively, but there's an obligation kind of, be quick about it. So, and they specifically noted there's an obligation to move as expeditiously, so as quickly and effectively as possible towards those goals. So there is expected continuity of progress. So it's not an absolute right that all these states have to offer these economic and social rights immediately. But it is expected that states will do their best to get there quickly rather than slowly. There's also a minimum kind of obligation to meet kind of like minimal essential levels of each of the rights protected by the covenant. So at the kind of very baseline, states should do their best to meet these kind of minimums and then strive for meeting the goals entirely. Um, Now, one example of where the covenant, the covenant, and especially kind of the probably not specifically the covenant as such, but the rights kind of specified by the covenant and how they've been translated at a regional level, is the one that I have on the screen there, the Social and Economic Rights Action Centre versus Nigeria. This was a case that was in front of the African Commission on Human and People's Rights. And this was an important case which showed that the nature of the economic and social obligations accepted by state parties to the African Charter is also not only informed by the ICE-SCR, but also has been quite explicitly recognized in this particular case. And it demonstrates quite nicely an indication of how these economic, social, and cultural rights will develop. Sorry, there was a communication in this case from a NGO, so the Social and Economic Rights Action Centre, and they alleged that oil production operations by the Nigerian government at the time, which is through a consortium of companies, primarily with Shell Petrol, caused environmental degradation and health problems for the local people in that area, and these were the Ogoni people. And it was alleged that the consortium exploited oil reserves with no regard for the health or environment of the community. That the consortium disposed of toxic wastes into local waterways in violation with international standards as well. And the Nigerian government itself was alleged to have condoned and facilitated these violations by actually placing the legal and military prowess and powers of the state at the disposal of the oil companies involved in this consortium. And in evidence at this case, the Nigerian army actually admitted, or one of its representatives, that it had a role in the operations of this consortium, which had left thousands of villagers homeless. And so, in front of the commission found that the Nigerian government had violated the African Charter, including the right to health and the right to a clean environment, which was recognized by its articles. And in its conclusion, it said that the right to a general satisfactory environment, as guaranteed under Article 24 of the African Charter, or the right to a healthy environment, as it is widely known, therefore imposes clear obligations upon a government. It requires a state to take reasonable and other measures to prevent pollution and ecological degradation, to promote conservation, and to secure an ecologically sustainable development and use of natural resources. And then the Commission referred to Article 12 of the International Covenant on Economic and Social and Cultural Rights, noted Nigeria as a party, and said that this article, Article 12, requires governments to take steps for the improvement of all aspects of environmental and industrial hygiene. And the right to enjoy the best attainable state of physical and mental health, which is in the African Charter, and the right to a general satisfactory environment favourable to development, also in the African Charter, obligated government to desist from directly threatening the health and environment of their citizens. So the state is under an obligation, as the Commission went on, to respect these rights, which also entails non-interventionist conduct from the state. Not to sponsor or tolerate any practice, policy, or legal measures that violate the integrity of the individual. And so the African Commission here found that there had been violations of certain economics and social rights in the African Charter, that all and especially focused on Article 12 of the Charter, that all people shall freely dispose of their wealth and natural resources. There were also violations on the right to property, the right to housing, the right to life, and the right to broader economic, social, and cultural development within the Charter as well. And so this was an important case to demonstrate that Nigeria was bound to protect and improve these rights for its citizens rather. And the Commission also, in its decision, noted that there were a minimum core of these rights that the Nigerian government couldn't violate. So even though potentially the Nigerian government may not have been able to breach the demands of the rights enunciated in the African Charter, which are very much informed by that of the ICESCR, they still had to meet some absolute minimum core obligations. So a good example of this in that judgment was that the Commission said that Nigeria was bound to try to protect and improve food sources and to ensure adequate food for all of its citizens. This is obviously a difficult standard for any government really to reach, even here in Australia, and let alone for a developing country such as Nigeria. But the Commission stated that in pursuing this aim, there still has to be a minimum core obligation where the government can't, for example, destroy or contaminate food sources, which is what the consortium here of oil producers was doing with the government support. So again, I think this was just a nice case of demonstrating kind of the regional applicability of these economic, social, and cultural rights, which have come from the ICESCR and have been translated at the regional level into the African Charter. Now, let's have a look at the treaty monitoring regimes. Much of this is kind of just noting, what we have here and who's looking at human rights throughout the UN system. We don't go into huge amounts of details with these because you don't really have to know the ins and outs of these in great detail for our purposes here. But it is something that might come up when we look at some more of the specialized areas, international law, in the second half of the semester. So the UN sponsored human rights treaties that we've noted many of them already. These include procedures for monitoring the implementation of the rights that they protect. They also create expert committees too that are supposed to be autonomous from the UN, but they are serviced through the Secretariat of the UN Centre for Human Rights in Geneva. And your text, I believe, goes in quite a bit of detail in terms of this institutional apparatus. But like I mentioned, it's only something that we're just going to briefly kind of note here. And I've listed some of these committees that have been established. For example, we have the Human Rights Committee under the ICCPR. There's 18 independent experts that operate on the basis of consensus. There's the Committee on Economic and Social and Cultural Rights under the ICESCR. And this is the committee I mentioned a couple of times in the previous slide, again with 18 independent experts as well. The Committee on the Elimination of Racial Discrimination under the Convention on Racial Discrimination also has 18 independent experts as well. We have the Committee on the Elimination of Discrimination Against Women, or CEDAW, with 23 independent experts this time. And the Committee Against Torture under the Convention Against Torture has 10 independent expert members, and they are often appointed from the Human Rights Committee to ensure kind of like a consistency of their decisions and jurisprudence. There's a Committee on the Rights of the Child with 10 independent experts as well. There's also, I think my last one there, a Committee on the Protection of Migrant Workers under the Convention on the Rights of Migrant Workers and members of their families with 14 independent experts. Now, when the enforcement mechanisms of many human rights instruments were under negotiations, states were quite reluctant to accept a right of individual petition. And they kind of preferred a process of review and comment upon state reports of compliance by a committee of independent experts. And so this committee system does reflect the political compromises that were accepted and agreed upon for each treaties, or each treaty rather, in the singular. And state parties have, since the initial negotiations, agreed to improve certain mechanisms to ensure rigorous scrutiny and accountability as well. But the Human Rights Committee system is broadly limited in a sense because each committee usually meets for only a few weeks each year. So they have quite a limited time to actually consider the issues that come across them. So, for example, the Human Rights Committee meets 3 times annually for a few weeks, and the CEDAW committee meets for 2 weeks in 2 sessions per year. And as these principles monitored by these committees are central to the global human rights system, effective scrutiny requires the establishment of permanent organs, really, which can fully investigate concerns and work cooperatively with the states involved. And in attempting to fulfill their missions, The UN Human Rights Committees have also quite often appointed special rapporteurs to gather and receive information, to liaise with states subject to complaints, and to work with other human rights bodies in the United Nations. In 1985, the UN Commission on Human Rights appointed a special rapporteur on torture to work with the Committee on Torture, for example, with the responsibility to report annually to the Commission. And many of these committees now have special rapporteurs that report annually as well. Now, these human rights committees have been seen as relatively effective within the limit of their mandate, and are generally judged to be relatively impartial by commentators as well as academics and other critics. Their members are usually elected by human rights experts, typically lawyers, and they are independent of their governments. There has been, though, a tendency for members of these committees to be disproportionately Western in their origin and education, though there are some efforts to kind of ensure a wider process of selection as well. And the work of the human rights committees, particularly through the general comments and concluding observations in specific cases, has proved to be quite influential in developing jurisprudence of human rights law, and also stimulated states to take measures that conform with their various obligations as well. Now, these committees also work with certain competencies and abilities to, have some kind of mechanisms of enforcement. And the establishment of procedural mechanisms for monitoring and enforcing human rights has been a really vital means of developing, our substantive content of human rights, enforcing those rights and giving a remedy and a redress to victims as well. These mechanisms were also negotiated as a part of these human rights treaties themselves, which are commonly over the 60s and the 70s. And because of this, they do reflect a cautious willingness to establish monitoring committees where these states would report on the implementation of their obligations to, and to which state parties could complain that other state parties were not complying with the relevant treaty. But the weaknesses in this UN committee regime became quickly quite apparent because states only rarely complain to a human rights committee alleging violations by other states, and states often fail to report. And when they do report, they often do so quite inadequately. So there were some initial problems there. But like I mentioned before, there has been relatively recent reforms now that gave certain human rights committees the authority to receive petitions from individuals, groups of people, and also NGOs, and to initiate egregious breaches of human rights. And these committees have also taken an increasingly robust approach to interpreting and applying the provisions of their constituent treaties. There are also other programs and actions of other UN bodies, in addition to these human rights committees, which include the various UN bodies as well, which we don't really go into too much here. But in terms of the broader jurisdictional and political approaches to human rights implementation broadly, the system is really quite under-resourced and subject to constant kind of risk of fragmentation, even though the committees meet annually and quite consistently within their mandates. Because a lot of the issues is the monitoring and the actual enforcement, because the rights of individuals or groups to make a petition remains still quite circumscribed. And to enforce human rights treaties, it really requires wider participation and more monitoring and more pressure on states. Um, there are also issues such as states appending, really wide reservations to treaty obligations. There's often overdue state reports and, like I mentioned before, inadequate ones too. And there's also a lot of weaknesses of the enforcement regime itself. And this, enforcement as well is a really important principle of any type of law or any type of ensuring that, principles and human rights are respected. Um, but in general, it is quite difficult to access any kind of enforcement regime under international human rights law. And one of the main reasons is that there's an established principle of general international law that international procedures for resolutions for disputes are not available until all local remedies have been exhausted in the potential state. And this principle also applies to the implementation of human rights. And a provision to this effect is included in basically all human rights treaties. So the affected person has to go through all of the potential domestic remedies before they can reach any kind of international law remedies or enforcements. And the rationale for this rule lies in the practical value of encouraging states to ensure that there's some kind of judicial or administrative procedures that are in place to enable the realization of these protected rights where they are needed within national systems. And if appropriate mechanisms are enforced within the domestic jurisdictions, then it's sensible to have recourse to them before appealing to international bodies. And because the remedy is a really integral part of these human rights that if they're breached, they should be remedied. If there's an effective remedy within the state, then it seems to be a contradiction to claim before an international tribunal that the state is in breach of its obligations. And the enforcement and monitoring bodies of human rights treaties have been engaged quite a bit in determining when international remedies may be invoked, which has developed quite an extensive jurisprudence that has demonstrated actually kind of providing a little bit of a loophole in this broad, generally flat international law principle that the exhaustion of local remedies is not always required, and especially not when they are unduly or unreasonably delayed and not likely to be effective as well. So uh, there's a case in Canada, which might be an example. I didn't know it in the slide because you certainly don't need to know it in any kind of depth. But there was a case where someone brought Canada to the Committee Against Torture, and they found that the application was admissible, even though Canada objected that the complaint hadn't actually applied for approval or even a judicial review in the Canadian courts, and this was around the granting of refugee status on humanitarian grounds. And so, therefore, there hadn't been exhaustion of local remedies. But the Committee the Committee Against Torture rejected Canada's position here and observed that that there was no need to actually exhaust these potential remedies because the right to grant refugee status in this particular case was ex gratia in nature. And any question of an appeal against the decision by the minister did not arise. And because the application for this particular risk assessment could only be based on fresh evidence and there was no evidence available in the case, then there was no need to exhaust these different avenues for appeal. So this obligation to try to exhaust domestic remedies requires that the remedy that is available has some kind of legal or objective foundation for success. So it actually has to be able to uh, like realistically be achieved. Now, non-compliance and the failure to cooperate with the human rights reporting regime, compounded by the reluctance of states to complain against other states, have focused implementation efforts upon the rights of individuals to petition the human rights committees. And practices since the 1970s under the UN Commission on Human Rights, racial discrimination and torture, and also at regional levels, such as by the European Commission and the Court of Human Rights, has demonstrated that individual petitions have demonstrated a much more like effective means of implementation of treaty rights than the state reporting system. And the advantages of a reporting system are that the initiative lies with the supervisory body rather than with an ad hoc petition by an individual. And that allows all, aspects of a complaint case to be examined. But these individual cases have been really crucial in driving jurisprudence in these areas and also driving the obligations of states and enforcement of them. And also like a finding of breach against a state in an individual case brought by an individual to a committee can also have a really powerful impact on public opinion rather than an abstract finding of non-compliance by the committee in a discussion just with other states. And also demonstrating like an individual remedy for a certain breach, that people can kind of connect to and understand rather than more abstract critiques, for example. It's also been demonstrated that this system of petitions has tended to lead to a more speedy change in the law or practice to the general advantage of all as well. And several of our UN human rights treaty bodies, a few of which we've mentioned, do have the capacity to consider individual petitions and often only where there has been an explicit declaration to this effect. So, for example, individual petitions are possible under the Migrant Workers Convention, where state parties make a declaration for that. And the Racial Discrimination Committee may also receive individual communications that are confidential, which also provides that committee to make findings on really important individual issues as well. And the CEDAW committee, which try to affect the Convention against discrimination against women, may consider individual petitions as well. And the Committee on Torture may also do so if there has been a declaration to that effect under the Torture Convention. And outside of these treaties, there's also been quite a lot of value in creating change and developing human rights jurisprudence through the procedures under the optional protocol to the ICCPR, which granted the Human Rights Committee competence to consider individual communications alleging violations of the covenant by state parties. So in this sense, usually the individual must be like a victim, that they have been personally affected. So individuals can't just bring complaints to the committees that challenge a law or practice that is contrary to the covenant. They actually have to be a victim in the sense that they've been like personally affected by the state party. And legal, like the so-called legal persons, like companies, cannot be victims and also don't have access to the right of individual petition, which is also usually a bit of a different conception than how we see companies domestically, where they kind of have this personhood. But there's still some difficult distinctions which are often made in determining who is a victim and who is entitled to a petition as well. It's not always a um, clear-cut event. And so this is also a place where the various committees have developed a lot of jurisprudence and have ruled upon in the past about, well, who can actually access these individual petitions. And and these conventions do try to make this quite clear in some respects. So the ICCPR says that where there's rights and freedoms of a person who are violated, they shall have an effective remedy. The CESCR has observed that there are rights under the ICESCR that are capable of application by a judicial and other organs of the state's legal system, and the other various regional treaties also note that individuals have the right to make a case or have a petition when they have been impacted by state activities. And so there's many also different regional and content-specific treaties which do differentiate whether individuals have the ability to access redress and how they can do that, which is quite complex and different among all of them. Now, most human rights treaties, though outside of this kind of the individual communications, do provide for the receipt by the relevant committee of state reports. And these are usually submitted every 2 to 5 years or so. They're usually then reviewed, they're commented upon, they form then the basis for reporting and recommendations to the General Assembly. As an example, the ICCPR in section or Article 40, subsection 1, says that the parties undertake to submit periodic reports on the measures they have adopted which give effect to the rights recognised herein and on the progress made in the enjoyment of those rights. And then after a state report is submitted, these committees can ask the state for further information and clarification. And then representatives of the reporting state may attend meetings at which the report is being considered. The Human Rights Committee, for example, may also receive information from NGOs, as I noted previously, like Amnesty International, as well as the International Commission of Jurists, to supplement the information provided by the state reports. The committees have also got various mechanisms to deal with late and overdue reports, such as the Committee on Racial Discrimination will seek information from sources other than the state parties if the state has been late or overdue with their submissions, such as like asking NGOs, for example. Now, once the review is complete following the submission of state reports, the committee will then produce a concluding observations. And it's also usual for the committees to produce occasional general comments on particular topics, which provides an opportunity for them to set out their interpretation and application of specific human rights as understood by the committee. For example, again, the general comments of the Human Rights Committee have had quite an authoritative influence in articulating the jurisprudence for national and international tribunals and administrative bodies, as well as setting guidelines for normative standards, even though they're not formally binding. And the CESCR, so the Committee for Economic, Social and Cultural Rights, has been also particularly valuable in setting out the obligations too under the ICESCR. The Human Rights Committee has also used general comments to deal with a whole range of issues, such as the right to life, to the threats posed by nuclear weapons. Despite this, and despite the ability for some of these committees to report back on state reports as well as make these general comments. That broadly, the reporting system has been quite varied in terms of its effectiveness. Many of the states don't produce reports at all or do so sporadically, and often with very serious delays. And also this obligation to report is also a additional burden on less developed states as well. And even so-called the developed states have been disenchanted by the time and resources needed for these kind of reviews. So there has been difficulties for all states to comply with these requirements. Um, Now, these treaties also have procedures where states may make complaints against other states. Um, uh, but there are also some of these that require states have to make a declaration to permit such communications. So this is the case with the Migrant Workers Convention as well as the Torture Convention as well. Uh, and then some of the committees then have different procedures than, what happens when a state makes a complaint. So the Racial Discrimination Committee may receive state complaints under the Racial Discrimination Convention and then may seek to resolve this in a dispute. And if the resolution is not achieved, then the states involved may agree to the dispute being submitted to an ad hoc conciliation commission that then reports back to the committee with their recommendations. Whereas the Human Rights Committee may receive state-to-state complaints where state parties have made a declaration accepting the competence of the committee. And then the committee may, if the states have consented prior, appoint an ad hoc conciliation commission to seek some kind of resolution. But these aren't, these commissions aren't binding on the states. So it's a relatively weak enforcement procedure. And even the ICESCR does not include an interstate complaints competence. But the Committee for the Economic, Social and Cultural Rights did propose in the early 90s that it be given some kind of mandate to receive petitions that might include state-to-state complaints. But in reality, the right of states to make complaints to UN treaty organs against another state has never been evoked under in like really any of the available procedures. Adversarial applications in respect of human rights are usually quite less acceptable to states than resolutions through usual diplomatic channels. So you don't see it all that often. Now, finally, on this slide, a brief point on customary law, which I've kind of gestured towards a few times. The fragmentation of human rights law through the various covenant and treaties and regional agreements that we've noted so far does risk some like fragmentation and fragmentation of these human rights when they're like expressed in so many different ways and through so many different forums. This is not only a bit of a threat that can undermine or fragment these rights, but also helps enrich general international law more broadly as well. So one of the issues too with the risks of human rights kind of expressed in this way and put down in this way is that states are kind of reluctant to ratify human rights instruments. And then others might restrict their obligations by putting down reservations to vital provisions. And there is an uneven pattern of participation in human rights treaties, as I've mentioned so far, and the threat to the integrity of the core principles of human rights has prompted efforts to try to identify human rights that are expressed in these various treaties more broadly to have customary law binding on all states. And individual and collective human rights have been recognized as obligatory, as customary law by the practice of states and international organizations and by international and national tribunals. And this is regardless of whether states have ratified the relevant treaty or have done so with various reservations. And even the General Assembly has declared the Universal Declaration to constitute basic principles of international law, as we've noticed previously. And even the Human Rights Committee has confirmed that there is a customary law status of many of the provisions of the ICCPR, and has concluded that states can't actually make reservations in relation to them. As well. And other work of scholars, the International Law Association, others have confirmed that many of these provisions constitute customary law, and are treated as such by national and international tribunals as well. Having said that, it's still quite common procedure for if cases get to national and international tribunals, for the parties to, if needed, to prove the customary rule in each instance. So this still has to be demonstrated usually in these tribunals, and usually still has to demonstrate the requisite state practice, as we also spoke about previously in terms of our customary law. There are some human rights and prohibitions that have been laid down and been recognized to be firmly established as customary law. And these involve war crimes, crimes against humanity, genocide, apartheid, systematic discrimination on the grounds of race, religion, and gender, slavery and slave trading, torture and cruel, inhumane, or degrading treatment or punishment, retroactive penal measures, prolonged arbitrary detention, the arbitrary deprivation of life, and causing disappearance of persons as well. And then on the positive sense, there are also other norms that have reached that customary law status and have been recognized to do so, such as the humane treatment of detainees, self-determination of peoples, rights of minority to enjoy their own cultures or religion or language, fair trial, including the right to be presumed innocent until proven guilty, equality before the law, freedom of thought, conscience, and religion, right, the freedom to marry, right to leave country, and the right of a refugee not to be returned to the state where they may be tortured or persecuted as well. So this is kind of a bit of an overview of the kind of substantive background of human rights, as well as some of the mechanisms of monitoring, the competencies of the committee, and also, excuse me, what kind of enforcement there may be. So now I'm going to turn to looking at a bit of a joint discussion around the history of human rights alongside the critique of human rights too, which kind of will provide a bit of a foundation for the discussion that we've just had, and also hopefully further substantiate some of the discussion in your textbook as well. So the UN rights process of the UN of the 1940s was really important for many different reasons, and one of them was that it gave each sovereign state an equal vote, and this broke quite starkly with the elite kind of moral authority that had been placed upon Western elites and Western institutions and countries, which had been very much present in the mandate system post-World War One. And the involvement of non-European states and representatives of the Soviet bloc in the drafting process of these human rights treaties seemed to many Western elites as a reflection of this kind of crisis of civilization that many felt threatened by firstly different political economic systems, as well as decolonization as well. And during the drafting of the Universal Declaration of Human Rights, for example, delegates from China and Saudi Arabia, among many others, sought to relativize this idea of like Western culture and remind European powers that a declaration of human rights can't just be based on a single cultural and particularly Western tradition. And the presence of delegates who had once been excluded from civilized law-making bodies changed the terms of the debate at the time. So, for example, China had long been forced to accept quite humiliating concessions in the form of incursions by European traders and missionaries. Muslim societies existed outside that group of states that before they could become civilized nations, had been known as Christendom. And delegates from these societies and from recently independent countries were unwilling to allow an attempt to formulate a list of human rights that enshrine the superiority of Western civilization. And so the social and economic rights in the Universal Declaration of Human Rights were the products of compromise. And many delegates sought to ensure that these rights also implied no actual obligations on states per se. And for instance, the United States delegation led the attempt to detach these rights from more radical political challenges to an economic order that was based on private appropriation and labor exploitation. The US delegation sought a compromise that would transform political demands for redistribution, which were reverberating around the world, into more flexible standards that were adjustable in line with various policy considerations, and so weren't on the same level as civil and political rights. And the drafters, many of the drafters of the Universal Declaration of Human Rights were concerned to ensure that social and economic rights did not unduly disrupt the status inequalities of civil society in the vast majority of the world countries at that time, and I mean, still arguably today as well. They reasserted a gender division of labor in which it secured male employment and female domestic labor, and this was bolstered by the state provision of a social safety net in the so-called Western industrial countries, and the colonial powers, especially France, UK, and the US, also sought to preserve racial segregation and colonial exploitation by bolstering the legitimacy of racial discrimination as a mechanism for determining entitlement as well. Now, after this drafting process and the implementation of the Universal Declaration for Human Rights, the 1960s was then a really important decade for the next stage of critique and contestation around human rights. In quite famous critique in 1966, Frederick Hayek, who is the famous neoliberal theorist from the Geneva School, described the Universal Declaration of Human Rights as an incoherent attempt to fuse the rights of the Western liberal tradition with an altogether different conception derived from the Marxist Russian Revolution. And when Hayek made these remarks, these kind of views were gaining quite a lot of ground. There were two legally binding human rights covenants adopted at the United Nations that same year that Hayek made his remarks, and they were unable to replicate the compromises that had led to the Universal Declaration of Human Rights that was destined to become binding international law, or was thought to be. These drafters produced two different covenants, which we've discussed already, the ICCPR and the ICESCR. And among those that refused to sign on to the Covenant of Economic, Social, and Cultural Rights was most prominently the United States. And it was often viewed with suspicion and alongside Hayek and other theorists of his persuasion termed it a covenant on uneconomic, socialist, and collective rights. So it was very unpopular amongst a lot of critics from that line of thought, especially from the United States. And its social and economic rights didn't attract a lot of domestic support within the United States, even from within the human rights community there, which had assumed it would be its kind of natural constituency. So this was there was important critiques reverberating from one of the world's major powers at this time for the two new covenants in the 1960s. And then in the 1970s, there started to be there started to be kind of appear a new generation of international human rights NGOs, which that came to prominence, and they pursued a quite narrow agenda of protecting what Hayek had termed classical civil rights, rather than promoting broader social and economic rights. And many of these were based in the United States, and their pursuit of quite narrow civil rights also reflected the 1960s critique, of these human rights expressed in these covenants. And the former head of the Human Rights Watch in the United States, for example, noted with quite a lot of displeasure that the Universal Declaration, by enshrining social and economic rights, was too much of a radical break with previous practice, and said that not everybody can have everything, and that the role of human rights should be to specify those very few things to which everyone is entitled. And even in more modern times, many of these NGOs, even though they've expanded their focus, have still largely restricted their focus to discrimination and restriction of certain rights, rather than the endowment of many of the social, economic, and cultural rights that were specified in these covenants. And many of these human rights NGOs flourished in the post-80s period of what we call in the political economy literature this neoliberal ascendancy, where these ideas of marketization, privatization, individualism was on the rise throughout the world, in which theorists such as Friedrich Hayek and others contended that it was meaningless to declare that everyone was entitled to food, housing, clothing, and medical care. And this neoliberalization of societies around the globe had basically made that self-evident. But back in the 40s, when one of these drafts had been created, and when these delegates were drafting these covenants, it was a totally different time, where it was an attempt to depict the social and economic rights that were being built on the workers' movements around the world, and was built upon the social progress that these movements had won. The rights to work, social security, a decent standard of living. These were the triumphs of the previous the movements of the workers around the world in the early 20th century. But this had really wound back by the time of the 1980s, and were increasingly off the agenda, or the human rights agenda, especially for many Western-based NGOs. And this period that preceded this one, between the Universal Declaration of Human Rights in 1948, then the adoption of our two covenants in the mid-1960s, seemed to be kind of a period of cascading right claims. There was victorious anti-colonial movements that changed the composition of the UN, changed the terms of the human rights debates as well. And delegates from newly independent African and Asian countries also declared at a very famous conference in the mid-1950s in Bandung in Indonesia that there is an inherent right of peoples and nations to self-determination as a prerequisite for the full enjoyment of all fundamental human rights. And this was on the back then of a couple of years later of further decolonization and further victory of independent movements. But even though this kind of force of anti-colonization, of independence, was brewing in that period between the Universal Declaration of Human Rights and our two covenants, which seemed like a bulldozing revolutionary force, anti um, anti-colonialists were recognizing that their newfound freedom, sovereign equality, did not actually grant them the independence that they had previously fought for. The first president of independent Ghana, Kwame Nkrumah, coined the term at this time neo-colonialism, which referred to the very subtle mechanisms that perpetuated colonial patterns of exploitation in the wake of formal independence, which actually restricted the ability for states, newly independent states, and their peoples to actually try to achieve these human rights. And Nkrumah argued that the achievement of formal sovereignty hadn't actually freed former colonies from the economic and unequal economic relations of the colonial period, nor given them actual political control over their territories. And he quite famously wrote that a state in the grip of neocolonialism is not a master of its own destiny. And one of the big points that Nkrumah singled out, which we don't deal with too much in international law course, but I'm of course very interested in because I'm a political economist by trade, is that of international capital's control of the world market, and the exploitative uses of international aid and aid conditionality, and also the pressure exerted by international NGOs, other states, and so forth on these newly independent states as well. And this form of neocolonialism emerged and became powerful as these struggles for independence appeared to succeed. And the struggle against neocolonialism then took the form of new demands for economic rights, including the rights to development and permanent sovereignty over natural resources, which is why you then see them in the international covenants. Now, back into the 1970s, and just kind of before the formal ascendancy of neoliberalism worldwide, there were still pushes, and this was now less than a decade after our two international covenants. There was pushes for the various producing companies of the so-called Global South to join together and operate the levers of price control. Because one of the big demands of the developing countries at this stage, or big concerns at least, was that their commodities that they put onto the market, which is usually a result of their colonial experience. So, for instance, if you were Sri Lanka and British colonialism had designated you a large tea plantation, effectively, then this is the industry that you had to use to be able to get foreign reserves to be able to pay for development. And the price of these primary commodities were highly fluctuated a lot. It wasn't like more modern commodities and industrial commodities such as television sets, cars, and those kind of things whose price would kind of regularly and steadily increase. These primary commodities fluctuated with even like weather events, with more forces of supply and demand and so forth. And so the developing countries in the early 70s said, look, we need to actually try to control these prices. And the newly formed Organization of Arab Petroleum Exporting Countries, or OPEC, had started to use their power to set oil prices, and that had bolstered the confidence of other actions of other, for producers of other raw materials to alter the terms of trade and transform an international economic system that was perpetuating exploitation, racial discrimination, and impoverishment of the third world. And this turn towards economic questions was really important because the UN General Assembly then passed the Declaration on the Establishment of a New International Economic Order, which firmly put the idea of economic rights at the center of all other rights, and proclaimed that all states, territories, and peoples under foreign occupation, alien and colonial domination, or apartheid had a right to restitution and full compensation for the exploitation and depletion of their natural resources by colonial powers. And this development of a human rights agenda backed by these economic demands started to get separated quite distinctively from the formal human rights agenda that was pursued by now the major human rights NGOs like Amnesty International, Human Rights Watch, and so forth, which depicted third world suffering as an internal problem which is caused by the failures of the post-colonial state. And so you had these two kind of competing rhetoric or discourses of human rights at this time. Now, once there was this neoliberal ascendancy in the 1980s, the the global political mechanisms and imperatives at that time then shifted pressure far more onto the developing states. I mean, I can't go into all the particular reasons why this is so, but in the early 80s, US President Ronald Reagan said that developing states, they have to embrace the magic of the market. And there was the quick death of the new international economic order with this neoliberal counter revolution. And I mean, much of the reasons was because of a huge debt crisis in 1982, which started in Mexico and then reverberated around the world, where a lot of international banks were a lot more hesitant to support developing countries, or at least lend them money or invest their money in these developing countries. And so a lot of these developing countries had to go to Western international organizations such as the World Bank or the International Monetary Fund to ask for loans, which then had a lot of strict conditions and basically conditions to impose a neoliberal open markets, deregulated, marketized, privatized economy. And so these so-called third world states in the 1980s were struggling under this weight of foreign debt, and their previous agenda of the new international economic order had been displaced by trade liberalization, deregulation, and privatization, which was also driven by the United States Cold War priorities as well. And so these demands for economic decolonization appeared more and more utopianism, that they were not, they weren't achievable. And so then by the 1990s, there was then a dominant international discourse about human rights, a global lingua franca. There was the end of the Cold War, the collapse of the Soviet Union, and the Human Rights Project was set more on remedying the harms of authoritarian governments, monitoring elections, advancing empowerment for minority groups, tackling lack of healthcare, and these kind of areas. And these various rights were very much not as focused upon on the economic and even social and cultural rights of the previous decades. And this new discourse around human rights, this more unified discourse around human rights, was accompanied by not only legal architecture but also a lot of international institutions, which many of which we have noted, like our special rapporteurs, our human rights courts, our various human rights committees, which also had a whole heap of civil society actors that drove new standards, and helped kind of ensure human rights rippled out into other areas of international law and practice as well. So now let's move on to some more specific critique of human rights, which is kind of, a little bit separated from our history. And I mean, there's maybe only just three that I'll focus on. I won't take too much time with this because I'm conscious of I'm probably running out of time of this lecture here. And again, this is more of your own interest, and I hope it is of some kind of interest. At least I find it really, really interesting anyway. But I can kind of separate these in three different categories. So firstly, human rights, are not neutral or apolitical. And with the defeat of the new international economic order and this kind of unified voice around human rights, there has been a view that human rights are neutral. They're apolitical. But this global ambition of this sweeping human rights discourse has long been disputed, even not even without a competing kind of demands of like a new international economic order, for example. And these kind of claims that human rights are universal and constant, does make them vulnerable to empirical critique. Because if you try to impose a given set of values on, the real existing polarity of human communities worldwide, it's going to be met with resistance on the ground of, different types of particularities in various places. Um, and there's been lots of challenges to even the drafting of particular ideas of human rights more recently, especially when human rights values conflict in a lot of in a lot of different scenarios. And it's also been critiqued from the aspect of active Western imperialism to kind of impose a Western standard of human rights across the world. And this has been a kind of common critique, especially since the 1990s. And many of the leading international organizations promoting human rights has been also criticized from this fact of viewing the individual as kind of the center of the moral universe, and has ignored the broader communities, collectives and group rights, which were really actually in the minds of the drafters in the 1940s and those early decades of the 20th century, which is also a really serious problem where scholars have argued that in a lot of places around the world, group and community rights are deeply embedded in cultures of the people, and so just focusing on the individual can be a very narrow way of looking at human rights, which is also quite political in and of itself as well. Now, second, human rights are colonial. And this also relates to the first critique as well. Um, and I guess as a antecedent to human rights, and I mentioned this before, when human rights were being drafted, there was a concern that there was a hierarchical comparison of cultures that had underpinned some kind of hierarchies of rights, where drafters, or there was concern that drafters were looking at the Western notions of human rights, which had set a certain hierarchy towards others. And so there wasn't a lot of reflection when these are being drafted on how these particular concepts could be challenged, and a colonizing impetus of them could be avoided. But instead, there was a kind of more triumphalism around establishing a universal discussion of human rights, but again, argued as not being universal in itself, but a instrument of Western ideas which had imposed some kind of colonial ordering rhetorically on what human rights should look like. And this again, these critiques have also been bolstered by the defeat of the new international economic order, where the particular rights that were focused on a critique of this idea of neocolonialism had been defeated. So there was a lot of discussion that human rights are insufficient, and also another kind of colonial tool. And I mean, one of the really prominent critiques of human rights from a colonial perspective was Aimé Césaire, who was a Martinician poet and political leader, and he described human rights as colonial racism. And he has a book, his discourses on colonialism, and he observed in that text that the wars, the world wars in Europe that had prompted the Declaration of Human Rights were only seen as so bad by the rest of the world, and needing a human rights framework because the victims were primarily white, and that previously, on the African and Asian continents, for example, there's huge amounts of violence which didn't ever cause any soul searching or appeals to international regulation and and these broad ideas of human rights because the victims were not white. And so his critique, and this is a critique of many anti-colonial authors, especially from the so-called global South, was, they made the point that this idea of human rights was not characterized by any kind of sorrow over colonialism and slavery, but was actually a different way of continuing the so-called civilizing mission of the various European empires. Um, and so, uh, I mean, this is also there's an important history behind this as well, because just as, and I didn't mention this in when we were talking about the history, but when these declarations were even being drafted themselves, there were still colonial powers imposing their will upon other peoples. So, for instance, the British were involved in massacres in Kenya in the 1950s, just as they were involved in many of the drafting of these instruments. And also, Belgium were also had their own personal fiefdom in the so-called Congo Free State. And they attempted to hide the crimes of their colonialism, just as the country was trying to struggle for independence as well. And so there was a lot of colonialism still about when these, or active and explicit colonialism about when these instruments were drafted, and these anti-colonial scholars argued that this wasn't at the forefront of the Europeans' minds when they were primarily, the ones still leading the drafting of many of these instruments. And more recent anti-colonial scholars have demonstrated that, well, this rhetoric of human rights has demonstrably failed in the more modern times, because if we look at those territories that had experienced colonialism, they're not thriving economic, politically, or in terms of justice today. And this also holds with indigenous peoples and descendants of formerly enslaved peoples in a settled colonial states as well, even though there was, optimism in the 1960s around some of the ideas of human rights, that we can see empirically that the actual promises within them has not dealt with either with the real trauma of colonialism that is still ongoing, and nor have they actually helped achieve a level of development and social growth in many of the places where it was most needed when these instruments were being declared. And obviously, there's a lot of reasons that we can discuss about that, but this is, just a brief note of what some anti-colonialist scholars have written about in terms of seeing human rights as a colonial tool. And finally, there's also a strong idea of human rights as legitimation of the status quo. That this approach of human rights is said to kind of fail to address power relations or political agency as well. There's a preference for state-centric, legalized and ahistorical conceptions of justice, which doesn't take into account, the history or the material conditions of people, and doesn't actually upset the state-centric status quo of our international system and also international legal order. And it's also placed a lot of power in experts and elites who are, again, usually taught and educated and work in the Western powers as well. And so the human rights has been accused of undermining its own emancipatory potential in this way. So I think I'll just leave it there, because I could go on more about these points, but I just want to give you a bit of a taste. And your textbook also touches on some of these quite briefly. But I think it's important to also note these critiques of human rights, because sometimes a lot of our international law texts kind of sees it as a overwhelming good development, which of course there's a lot of positives about having this rhetoric and discourses around human rights, and also the material implementation and monitoring of human rights breaches around the world. There's obviously like huge benefits for that as well, but there's also significant critiques around the world too on these. Now, team, that is everything for us today for our lecture. Thank you very much for staying with me. We have our tutorials coming up this week. I look forward to seeing you in class. And thank you so much for your continued engagement so far this half of the semester. And looking forward to seeing you in the second half too. Right, talk soon.